On March 20th, 2025, Byron Laws appeared before Judge David Fletcher in the Harris County Criminal Court in Houston, Texas, regarding a pending charge of driving while intoxicated DWI, with a blood alcohol concentration greater than 0.15. The alleged offense occurred on October 5th, 2021, following a traffic stop initiated after a witness reported an intoxicated driver weaving between lanes. Officers conducted field sobriety tests and obtained a breath sample registering 0.15. Mr. Laws was arrested without a warrant and later formally charged by information filed by the district attorney. Mr. Laws was represented by recently appointed defense counsel, Anna Eddy, who requested reconsideration of the original probable cause determination supporting the warrantless arrest. Counsel relied on constitutional and statutory protections, requiring a timely judicial finding of probable cause by a neutral magistrate. She cited the United States Supreme Court's decision in Gerstein v. Pugh and Article 14.06 of the Texas Code of Criminal Procedure, both mandating prompt review of warrantless arrests. Central to the dispute was whether probable cause must be established solely through the Sworn District Attorney Intake Management System, DIMS, report, rather than unsworn police offense reports. Defense asserted that the DIMS summary lacked sufficient facts, thereby undermining the legal basis for the arrest and charge.
On Laws.
Okay.
Is the last name. He's on bond.
Okay.
He has a BVR, but can we hear PC on this one?
Sure.
All right, there's this.
You don't think there's PC?
Laws.
No.
Yes,
You don't think there's PC?
I don't, looking at the DIMS, but reasonable minds can disagree, Judge.
Have we done PC on this before?
I don't know. This is an older case and I just got appointed on it last month. So,
Did you already approach on PC on this?
I have not.
Don't worry about
And
it.
I'll just be honest, Judge, I had assumed because of the age of the case that PC had been done. But,
Of course it has been,
right.
but there's a new set of eyes, you know? Okay, ready?
Yes, Your Honor. Sorry, just reading through, it's 2021 case. Thanks, sir. All right. On October 5th, 2021, the officers were dispatched to a DWI call. Excuse me. Activation. Okay. Officers were dispatched to a possible intoxicated driver call. The witness stated he observed the defendant to go in and out of lanes as well as making a turn on the highway, heavy traffic. The officers conducted a traffic stop. The officer observed the defendant had glassy eyes, slurred speech, odor of alcoholic beverage, and poor balance, and a article with quiet, please, cold beer inside the vehicle. The FMSTs were conducted. It was a 6 out of 6 on the HEN, a 7 out of 8 on the walking turn, and a 4 out of 4 on like stand. The breath is a 0.15.
So according to the DIMS, which is the sworn statement that we use for PC, it just says the officers initiated a traffic stop on the defendant's vehicle at an address. And there's no reason given in the DIMS for the stop.
She read something different.
That was
Yes.
not in the DIMS.
That seems to be from the offense report.
Sure, I mean, what's,
But I thought for PC, we just used the DIMS because that was sworn to, and not getting into the.
show me where it says that. I don't know of any rule that says that it's, PC has to be done on just the DIM.
Okay,
You know, I don't, if you can direct me to something,
okay,
but I've
and that just may
never,
be my misunderstanding of a
yeah,
policy.
I don't, and I've heard this before.
Okay.
Right, but I can't, I've never seen anything where someone has ever directed me to saying, hey, PC is only,
Well, it's
has to be just on the DIMS, you
because the
know?
DIMS is sworn, and just like when Judge Powell was up here and he wanted to get into the facts, he couldn't.
I mean, if he's getting into the facts, then that's something different, right?
Well, and getting into.
Sworn document too.
The offense report's on a sworn document.
I mean, I guess, Your Honor, my thing is it's a public record that they're using the DIMS taking the offense report. And also, I have never seen it where we have to rely solely on the DIMS for probable cause, since it's probable cause. In fact, when we go to the grand jury,
You asked me for a reset.
that's all offense report, that's all DIMS, it's everything that comes in, it's even evidence, and that's probable cause.
Yeah, I don't know. I don't think that, I mean, let's look, because I don't know.
During the early hearing, Defense counsel questioned whether probable cause had ever been properly reviewed and requested a fresh judicial determination. Counsel noted that she had recently been appointed and was uncertain whether the issue had previously been addressed. The court agreed to examine the matter. The prosecution summarized facts drawn from the offense report. Officers were dispatched to a possible intoxicated driver call, observed signs of impairment, administered standardized field sobriety tests with failing scores, and recorded a breath test of 0.15. However, defense counsel objected to reliance on those details, emphasizing that the sworn dim submission, the official probable cause document, did not state the reason for the traffic stop. She argued that only sworn statements may constitutionally support probable cause. The court questioned whether legal authority limited review exclusively to the DIMS report. Counsel referenced a prior Harris County class action lawsuit and settlement requiring sworn factual statements within DIMS for warrantless arrests. She maintained that reliance on unsworn offense reports would contravene the Fourth Amendment's oath or affirmation requirement. The judge expressed uncertainty regarding the proper scope of review and paused proceedings to examine the legal framework and settlement terms before ruling on whether supplemental reports could be considered.
You know,
Okay, I'll
and I'll,
go check with
sure.
Ms. Rogers.
Yeah, I would.
Hey, you ready? Come on.
Yeah, I just want to approach on bond conditions for Mr. Bardin.
Okay.
BARDN.
So you got appointed Mr. Albardon?
Yeah.
Great. Okay.
He has a residency restriction to stay away from his father's house. That's where him and his siblings live. And I want to approach you about lifting that up to no harmful or offensive contact.
And I'm okay. So he's Mr. Albardon. Come on up. Your lawyer wants me to change the conditions so that you can go back to the house. But I want you to understand that if you have a very tumultuous relationship with these people where you're always butting heads with them, it's not going to go well. I don't want you to have any threatening or harassing contact with them. What is threatening or harassing doesn't matter what you think. It is what they perceive. So if you go like this, is that threatening or harassing? It most certainly is. And it can land you back in jail. Do you understand? So if you cannot be nice and if you cannot get along with brother and sister or dad, be very careful. Because if I get wind that it's not going well and that you're threatening or you're putting anyone in danger or you have a weapon, I will put you in custody. You understand? Okay. All right. I'm done.
Thank you, Judge. I'm excused.
Mr. Albardon, the only thing I'm taking off of the protective order is the residential restriction. Everything else in the protective order stays. So if you threaten them, if you harass them, they can charge a new case on you. Do you understand?
Yes, no.
Okay. All right.
How would convey that?
And if you can file, no, now we need,
State bond condition?
yeah. So, Mr. Reedy, we need new bond conditions. He can't leave just yet. So we need him to sign no
Okay, I
threatening
told
or
him to
harassing.
put right there not to leave.
Okay.
Is that for your bond? Because you are here.
Yeah.
Stacey.
Hey, Herbert.
Okay.
Wait,
How are you, Judge?
What's new, man?
Same old.
Did you can pick a day?
Well, I have Monday and Tuesday are not good for me. Wednesday or Friday of next week is fine. I mean, I have a few days every week. Just
All come together with a meeting of the minds?
I think it's from what it sounds like, our officers we need two officers. One is, yeah,
One is unavailable on Wednesday and the other officer is unavailable on Thursday and Friday. I've reached
So
out.
go into the next week.
Yes, yeah, okay.
I don't care.
Both of them to find out their availability for next week. I'm just waiting to hear back. The next week after that.
Okay.
Yeah.
okay.
No stress, man. We have enough drama. Just pick a day. I don't care.
I'm not
Just
looking
make
for-
sure that, like, I don't want to keep doing this, though.
No,
This is
that's-
like,
that's
this is the
why we
last time.
Before we said, hey, go next week.
If we set this for the next hearing and one of the officers comes back and says, I'm sorry, I can't do it. I don't we're going forward without that.
Yes.
All right?
All right.
Whatever you want,
All right.
of course.
Sure.
After reviewing the legal background, the court and counsel further discussed the implications of the Harris County settlement arising from Lease versus Harris County. That agreement required officers to swear under penalty of perjury to facts entered into the DIM system to ensure constitutional compliance in warrantless arrests. Defense counsel maintained that this sworn summary must stand alone and contain all essential elements establishing probable cause. Because the DIM's report did not specify the basis for the initial stop, counsel argued the record was facially deficient. The prosecution contended that offense reports are official government records and that officers could face criminal penalties for falsification. Nonetheless, the court acknowledged that such reports are not sworn affidavits and may be supplemented over time, which had undermined their reliability as the sole constitutional basis for probable cause. The judge indicated that, although alternative interpretations might exist, the county had agreed to a heightened standard. He stated his intention to adhere strictly to that standard rather than rely on unsworn materials. The court further clarified that even if he found no probable cause at this stage, the state would retain authority to present the case to a grand jury for indictment based on broader evidence.
To evaluate it. It's an old case, Your Honor, but they asked if you could reset it, which I'm in agreement.
This is an interesting one.
Right, it really is.
A week. We filed for a week.
Yeah, sure, yes.
Do you have an offer on the case?
Just want to do one, just the,
Yeah.
I just want to do one little case law
Not a problem.
thing. I think
Is discovery complete?
it's gonna be complete.
You've got an offer?
I think we're gonna be able to resolve this case.
Okay, so I guess set it for next week
All right, sir.
and then we'll come back
I
and,
just want to do one more little case law.
no problem.
Sure. Thank you both.
Hi, Ralph.
Thank you. Session.
Hey, Anna, come on. So you're saying that it doesn't, the DIMS has no reason for the stop, right? Is that what
Yes.
you're saying?
The sworn statement, and speaking with Ms. Rogers, we're looking, but it's not,
And I'm looking to. I
okay.
am too.
There was a class action lawsuit, and as part of the settlement,
That's the.
the agreement was that Harris County would use the DIMS to support
Okay,
PC, but we're getting that all together.
me too.
Okay.
For the 26th. All right, there you go. You're good to go. You're welcome.
Was there a result for that?
Yes.
Or is it in action now?
No,
No, this was some time ago. So this was before the DIM summaries had an oath or affirmation at the bottom of it. So there was a class action lawsuit brought by the Civil Rights Court. And out of that lawsuit, it was just allegations of Fourth Amendment violations because when a warrantless arrest occurs, the Fourth Amendment requires that a neutral magistrate make a finding of probable cause supported by oath or affirmation. So as a result of that lawsuit, Harris County settled and said, okay, we're not going to concede that we were violating the Fourth Amendment, but we will now include an oath or affirmation.
Okay.
So I think it is a Fourth Amendment issue.
I'm curious, so I'm curious, for PC purposes, can state use an offense report to supplement a DIMS? Or are we strictly going in the four corners of the DIMS and nothing else? I don't know.
well, the four corners of the DIMS is what's sworn to, the offense report is not.
I find that really weird. How is it that they're creating an offense report and they don't swear to it? You know, because there's, in the offense report, you also have a search warrant. Like 9 times out of 10, you've got a blood search warrant, and that's sworn to.
That, Your Honor, if the officer makes something up into the office report, he is committing a crime. So I mean, I don't say that the office report is not sworn to. It's a government record that this officer is putting his name on. If he makes something up or if he lies about something, that is a crime.
Right, but filing a false government document is a different crime than perjury.
I get it, but
Wouldn't that be filing a false,
Right, but perjury's
an official document?
a different crime. Because
No, but it would also under the purview of filing a false,
Well, Judge, if an officer
Also-
came into court and was asking for you to sign a search warrant and they just gave you their offense report, that would not be enough for their search warrant. And it's kind of the same idea. Because this is a warrantless arrest, there has to be someone swearing to the facts to support probable cause for that arrest. And similarly, with the search warrant, it has to be supported by oath or affirmation. This wasn't a warranted arrest. It was a warrantless arrest. And so it must be supported by probable cause. That includes an affidavit.
Was there blood in this case? Right. Okay, give me 5 minutes.
Okay.
Huh? Okay.
If it's okay with you, we'll take.
Can you show them?
Yeah, that's fine.
Hey,
Please point.
Last name is Bledsoe.
Letsa?
Bledsoe.
Okay, you want to bring them on? Are we going on the evading and the terror sector that's going to be dismissed? Good morning, Mr. Bledsoe. You were charged with evading arrest or detention. You're facing up to a year in jail and or a $4,000 fine. You've worked out an agreement where they're going to dismiss your terroristic threat in exchange for your plea on the evading arrest. You need to understand that evading is an enhanceable offense. This is going on your record today. It'll be there forever. From now on, if you ever run from the cops again, you'll be facing a felony charge, years instead of days. Do you understand?
Yes, sir.
Not only that, it's a minimum now of 90 days for any new cases that you pick up in here. You're giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. Once you plead guilty, it stays on your record forever. Is this what you want to do?
Yes, Your Honor.
How do you plead to the offense, sir? Guilty or not guilty?
Good, sir.
I'm going to find you guilty. I'll send it to you with agreement. If it's enhanced, it'll be abandoned. Good luck, sir.
Thank you, Judge.
Anna.
I'm working with Mr. Gladstone.
Anna,
Oh,
you ready?
yes, Judge.
Mr. Laws, come up. We have court orders for a reason, and when you don't follow court orders, bad things happen. Do you understand?
Yes.
You were ordered to get an interlock and you didn't get it, or a portable device, and you didn't get it. That's unacceptable. When you don't, there are serious, serious consequences. The only thing I'm asking you to do, don't endanger my streets. Don't kill someone on the road. Do you understand?
Yes, sir.
I'm going to find no probable cause in your case now. But if you come back with a new case and you don't follow court orders, it's really not going to go well for you. Do you understand?
Yes, sir.
All right. Good luck.
Thank you, Judge.
I think that we are,
Sorry.
it's okay. No, and I think you're right. We were going through the lawsuit and, 2017, the county came into an agreement where we're basically holding it to a higher standard, so to speak. I mean, theoretically, could I weasel out of it? Yes, but I don't want to, I want to stick with the agreement that the county came to with the district attorney's office,
So, not saying it's this, I'm just for curiosity.
The DIMS has to state an offense, right? It has to have all the elements of the offense to go forward. The reason, I would presume that offense reports don't is because they're continually just updated and they're amended and they supplement it. So it would be unreasonable to have an officer every single time they swear to over and over and over and over, because shit, you might get like 15 supplements.
And here's my question for the board, and with, I'm not saying we're gonna do this in this case, I'm just saying, for cases going forward. To me then, does that then behoove, does that say we can't take it to grand jury?
You can, of course you can.
So,
Yeah.
Just because I find no probable cause on something, if you want to go indict it, go do it.
right, okay.
Absolutely. There's nothing barring you from doing that, right? Because if a grand jury finds something different, then that's on them.
Yeah,
As
and-
far as me, I'm going to just hold to the standard that we agreed with the county in the
I just-
lawsuit.
Yeah,
I'm just, and this is for my own.
And you, look, you're not gonna hurt my feelings if you go to a grand jury. I don't
I know,
care.
I know you, Judge.
Oh, really?
I just, so we wouldn't be held to that same
You need
standard.
to do, you need to do what you think is right.
Okay.
Like, I'm gonna do it, and like
Absolutely.
she's doing it. The problem is that whoever had the apps, they didn't dive into it and really look into it as Anna did, you know? Not everybody is,
I understand.
which is good.
Thank you.
Gotta love you.
After following the analysis, Judge Fletcher ruled that the sworn DIMS report did not contain sufficient facts to establish probable cause for Mr. Laws' warrantless arrest. Specifically, the absence of a stated reason for the traffic stop rendered the summary incomplete under the constitutional and settlement-based requirements. Accordingly, the court formally found no probable cause to support the pending charge. Before concluding, the judge admonished Mr. Laws regarding compliance with prior court orders, noting that he had failed to obtain an ignition interlock or portable monitoring device as previously directed. The court warned that future noncompliance could result in serious consequences. Nevertheless, the immediate ruling addressed only the probable cause issue, because the charge had been filed by information rather than indictment. The judge advised that the prosecution could still seek review by a grand jury. Under Texas procedure, a grand jury may indict upon a finding of probable cause supported by sworn testimony. Despite this option, the state elected to move for dismissal, while reserving the right to refile the charge later. The court granted the motion and dismissed the case. As reported, no refiling had occurred at the time of the summary, leaving the matter concluded without conviction.